I think you could start recording, pull up the agenda. We have not. Be over Zoom at some point. Yeah, I think quite some time ago. I think you're kind of doing this.
So yeah, it's like kind of meet when we were talking about the parking spots.
Oh, yeah. All right, well, let's get this rolling and I'll get are you recording, Lonnie?
Yes, and we have 3 members online, Sarah, Stuart, and William.
Just encourage myself.
Hi, Dom.
Hi there.
Greg Woods just texted me saying he's looking for the Zoom invite. I will forward this to him.
You wanna wait a couple minutes till he gets on? Probably.
Is he a member of the committee also?
He is a Board of Appeals member, so maybe one of the first things we should do is go around and have everybody introduce themselves.
No, I mean, the board, to my knowledge, the board has never met collectively. A year or so. I certainly haven't.
I'm trying to remember in the last time. We had to be.
So.
Building goals.
We actually meet in person several years ago when I first joined in Aspen, but that was our only in-person meeting.
All right, well, let's do this. Let's get going this way. My name is Richard Neely. I'm the Assistant Picken County Attorney. I go by Rye, so that's fine. You can call me whatever you want. Typically I wouldn't open the meeting because that's usually the chair's job, but we're gonna elect the chair. So today is the February 8th, 2024 Board of Appeals meeting. This is a Picken County Board of Appeals. I think let's start with having everybody introduce themselves, starting with the Board of Appeals members and then maybe staff. And then we can go ahead and elect a chair. And once that happens, we can go follow some of the rest of the agenda and we can talk about, and then we'll let the applicant or the appellant introduce themselves. So as I said, I'm Richard Neely. I'm the Assistant County Attorney.
I'm Tom Marshall. I'm a retired mechanical contractor.
Wayne Stryker, I'm Stryker Brown Architects, Aspen. I'm fresh to this, this is my initial thing. So although long ago, I was on a solar board for the city of Aspen.
Let's do some of the online folks now.
Good morning, I'm Bill Argyros. I'm an attorney. I'll say that I am not acting in the capacity of an attorney today. I'm simply a board member. I won't be offering legal advice per se.
Hi, I'm Stu Bohart. I'm an investor. I'm the deputy CEO of a 55 billion endowment and have lived in Aspen for 3 years where my daughter is a ski racer.
Sarah Broughton. I am an architect and owner of Roland Broughton Architecture and Urban Design. Been in Aspen for 24 years.
Greg Woods, owner of GF Woods Construction. Been building up here since the early 2000s. Do most of our work in the downtown core, but within the city limits primarily.
I think that's all the Board of Appeals members, right? Let's, why don't staff introduce themselves?
Sure.
I'm Jeff Erickson, Chief Building Official. Been the Chief Building Official for a couple of years now, and this also is a new process to me. So thank you for bearing with us.
I'm Leslie Lamont, I'm a caseload planner in the Community Development Department. I'm Larissa Lamont, I'm Community Development as well, Development Services Manager.
And I'm Bonnie Shiles. I'm the admin to planning and zoning and just help on meetings.
Great, so I see,
Oh, sorry, go ahead.
please.
I wondered if the assistant county attorney had a recommendation for a board chair.
I don't have a recommendation, but I was about to ask if anybody in the room would volunteer to be the chair today. I'd be more than happy to help the chair move along through procedure. And I was gonna go over some procedure after we elected a chair. Would, anybody be willing to do that today?
Well, who was the chair previously?
I do not know. It's
Good
been,
question. I think we elected a chair at that last meeting. Greg Woods might know that. Are you there?
Greg's there. I think he should.
Yeah, I'm here. No, I don't believe the chair was ever elected or appointed.
Remember we had the meeting at City Hall about code issues?
Uh-huh.
I do. I don't. Sarah, do you recall?
I do not recall, I'm sorry.
Okay.
Do we need someone who's in person, correct, to chair?
I think it's easiest to do it that way, but if we don't want, if somebody in person doesn't want to do it, we can have somebody on the appearing virtually to do it as well.
And it's chair for this meeting, it's not chair forevermore, correct?
Given the infrequency of the meetings, I think it would be just fine to assume that it's for today.
So anyone in the room sticking their hand up? I can't see.
Anybody want to do it?
I don't think we're eligible.
I suppose I can do it. I'm in person.
Okay, that's great.
Thank you.
don't-
chaired meetings before.
Yes, not successful.
And who was that? Who's,
Wayne Strike,
okay, so do you need a motion that he be appointed chair? If so, I'll make that motion.
Okay, we have a motion, it sounds like. We have a
Yeah.
second.
Second.
I'll second.
discussion? All in favor?
Aye.
All right,
Great, thanks a lot, man, I appreciate it.
Thank
Do
you.
you have a copy of the agenda in front of you?
I don't.
Okay.
Your chair does not have a copy of the,
We'll get with Bonnie here.
but he soon will. Thank you.
So we got through the election of chair. The next item on the agenda is comments, and I'll turn it over to Wayne. Looks like the first item agenda is any commissioner comments not related to today's topics. And if there's none, that's fine.
Do we have a commissioner with us?
That would be you all, the commissioners, Board of Appeals members.
Oh, the Board of Appeal Commissioner, okay, not county commissioner. Well, okay, comments from any members of our committee, the board? Anybody? Going once? I do not.
I do not. I was gonna talk about the issue a little bit because I'm confused, but, no, I don't have any info.
Yeah, we'll get there, I'm sure.
Yeah.
Any comments from the planning staff?
I'm sure we will have plenty of comments.
Okay, I suppose these are general comments, not specific
No.
to us
Usually
before.
that would be like procedural stuff or agendas for the next meeting. It's not really something we have right now, so.
Is someone taking minutes?
Yeah, we're recording the meeting.
I see Bonnie's got a pen in hand and she's playing fiercely.
Perfect.
Any other planning comments? Now, public comments, members of the public. Mitch? He's shaking his head.
nothing not on the agenda.
And we have no one online, so.
Okay, so we're on to item number 3, which is board action. So we are here to hear Bear at the Door LLC represented, and Jeffrey Erickson, building official for Picken County. And let us, begin the proceedings with that, and I'll turn it over to you, Rod.
Yeah, that's fine. I'm just do a quick overview of the procedure that I anticipate taking place. And that would generally be a brief staff presentation and introduction to the issue at hand, followed by the property owner appellant's argument. And after each of these segments, the Board of Appeals is free to ask questions of staff and then of the appellant, followed by staff's argument and an opportunity for an appellant rebuttal after staff's argument. After each of these points, the Board of Appeals is free to ask questions. Once appellant's rebuttal is complete, the Board of Appeals can discuss, and if the Board of Appeals is prepared to make a decision, and do that at that time.
Let me jump in and back up slightly, because this is more of a general comment, a general discussion. Could you summarize the authority of the Board of Appeals, and in a general way, define our the limits of our authority and where we should keep our discussion?
Sure, I can do that. So the Board of Appeals is empowered to hear appeals from a determination made by the chief building official or other building department official interpreting the building code, the Picken County Building Code. So the Picken County Building Code is part of the larger Picken County Code in general. And this board that we have here today is empowered both by the Picken County Code as well as by state statute to review decisions from the chief building official. And in reviewing that decision, the Board of Appeals is empowered to review the decision and either overturn it or uphold it, the decision, or modify the decision if appropriate. So that's some of the bookend that we have. The standard that you're applying today is whether the applicant in this case has pursued their building permits in good faith. And if that is the chief building official has determined that they have not.
Right.
So you're reviewing that determination.
So we are actually beyond the code. We're not here to simply say, well, the code says this, therefore. We are here to, in a general way, hear the circumstances of the situation and make our own collective determination of the substance of all that we see.
And generally, that is correct. You are somewhat bound by the code inherently because the language at issue is in the code.
Right.
But you're allowed to evaluate all the factual circumstances that are presented to you today to determine whether you believe that the chief building official's determination is correct
Right.
or not.
Okay.
To the extent that there is an effort for the board to make a motion one way or in the future, and we need to craft that motion or, figure out what that looks like, we can have a larger discussion at that point. But, what we're gonna hear today is the applicant's arguments regarding the factual circumstances presented by the building permits, and then the chief building official's response to that, essentially.
And that along the way, we can rely on you to guide us as far as a lettering point of the code.
I will do my very best to do that. And you can ask me questions at any time. And we'll, we haven't had a Board of Appeals proceeding like this in a long time, so we'll just have to work through it and we'll get there. But yes, please ask me any questions. Jeff, of course, is very knowledgeable of the building code, the content of the building code itself. But I will, as far as trying to interpret it and things like that, I am more than happy to help the Board of Appeals along with this.
Okay, exactly, good. I wasn't referring to you might not know entirely factual about it, but I am not. Even though I'm an architect,
Sure,
there's a lot of code
there's a lot of code.
and there are a lot of jurisdictions. So, okay,
There's only one code section, applicable today, so that's good. Yeah, we don't have to deal with the whole code.
oh, good. So maybe,
I'll get into the code
and
section.
you can, is it short enough you can just read it to us?
Yep, got it.
Terrific,
Got it.
okay.
Yep.
Therefore,
I think the thing to do is to have staff make their initial introduction and presentation to give you an idea how we got here. And then you can ask, the board can ask some questions of staff, and then we'll turn it over to the appellant property owner to make their argument. That works for the board.
yeah, hopefully, the board that's remote will jump in and participate as if you were here.
Sure, we'll keep an eye on the screens up here and down
Okay.
here, and hopefully everybody does.
Terrific.
Jeff.
Sure.
Sure. So I'm Chief Building Official. We're here today. The appellant here is appealing my determination that the building permit applications submitted for 270, 445, and 441 Nicholson Creek Road, lots 1 and 3 have expired 1 year after the intake acceptance date. The appellant is alleging that the chief building official made the determination without a full understanding of all relevant facts, that the owner failed to pursue the applications in good faith. The applicable code section is section R 10532 out of the 2015 International Residential Code, Title 11 amended to say, section 10532. An application for a permit for any proposed work shall be deemed to have been abandoned 1 year after the intake acceptance date, unless such application has been pursued in good faith or a permit has been issued. The building official is not authorized to grant further extensions. That's the code section that we're talking about today. I reviewed the documentation associated with each of the 6 permit applications we are discussing today in making the determination that the applications had not been pursued in good faith and therefore had expired. My primary consideration was the applicant's responsiveness to the deficiencies and specific issues raised in the review process and their ability to resolve those issues within the 1 year time frame. The projects we will look at are for Lot 1 at 270 Nicholson Creek, and it's for a new single-family residence and a conditioned agricultural structure. The permit applications were deemed expired after 1 year and have the same timeline and deficiencies raised by staff. So we have Lot 1 that has 3 permit applications there. And as I said, they have the same timeline, same deficiencies. The permit applications for Lot 1 were submitted on August 26, 2022. That's for all 3 structures. They were sent to review agencies for the first round of review. The agencies that review the first round include Pickens County Solid Waste Center for the Green Halo program, Pickens County's Planning Engineer, Pickens County Zoning Department, Roaring Fork Fire Rescue, and Pickens County's Environmental Health Department. All of these review agencies must approve prior to the application moving forward to the building department. During this review round, there were multiple deficiencies from multiple agencies. It is the applicant's responsibility to not only respond to these deficiencies, but to make sure there are no longer deficiencies. Although there was communication with staff during this time, the resubmittal never happened. Therefore, the permit application did not proceed to round 2 for review with the referral agencies and did not proceed to the building department for review. 8 months lapsed between the date of the deficiency report and the permit application's expiration date. The applicant has provided a detailed timeline of communication with Pickens County staff over the 8-month period. And they are claiming the permit applications were pursued in good faith. The entirety of Pickens County staff that has been involved with these projects do not agree that these permit applications have been pursued in good faith. For 8 months, the deficiencies were in the applicant's responsibility to respond to and to resolve. As a chief building official, I have the responsibility of determining whether a permit is issued in good faith. While there is not a specific definition, the CBO's policy is to only grant an extension for permit applications where Pickens County or a referral agency is at fault. For example, a permit application sits on a review agency desk for an abnormal amount of time and thus delaying the permit. The pursuing the permit is not caused by the applicant. Put another way, the CBO will only grant an extension if the circumstance causing the delay is beyond the applicant's control. After reviewing each application thoroughly with my staff, I determined this was not the case. On August 26, 2023, exactly 1 year after the intake acceptance date, the permit applications expired. It's important to note, even if the permit applications would have made it to the building department for review, there would have been deficiencies from my department as well. The applicant was informed at permit submission that PV solar permits are required to issue concurrently with the building permit applications. This review generally takes 4 to 5 weeks and a completed application and no deficiencies. And the applicant failed to submit for this application as well. That was lot 1. Now we'll get into the second lot, or the second project, which is lot 3, and that's 445 Nicholson and 441 Nicholson Creek Road, where there's also 3 permit applications. One's for a new single-family residence, a conditioned agricultural structure / garage, and a conditioned agricultural structure / CDU. All 3 of these permit applications were deemed expired after 1 year and have the same timeline and deficiencies raised by staff. When the building permit applications were submitted in September of 2022, the applicant was in the review process with planning to obtain approval of a new driveway alignment to access the building envelope on lot 3. Staff and the applicant agreed that proposed alignment was preferable. This review did not include any review of the proposed residence. The review process for the driveway had not been completed, but staff agreed to accept the building permit application for review with the original / not preferred driveway in order to preserve the applicant's vested right for the residence on lot 3. The building permit application was put on hold for completion of the land use process for the new driveway alignment. The new driveway alignment was approved in October 25th of 2022. The associated activity envelope site plan was recorded in February of 2023. And the land use approval for the new driveway alignment and the construction documents were expected to be submitted once the activity envelope and site plan were recorded. The next communication from the planning consultant was received on July 14th, requesting to amend the activity envelope to accommodate the required draining improvements. The applicant was still in the design phase of this project 10 months after submitting the building permit applications. 2 months later, with new information having been provided, and the building permit applications expired. So that's my brief summary of both lots 1 and lot 3.
I have a couple questions if that's all right.
For the record, could you say your name, Stuart?
Stu Bohart. From the August application to the time when deficiencies were reported, how much time lapsed?
Okay, so let's refer to each as lot 1 or lot 3.
There were no deficiencies on lot 3.
The deficiencies on lot 3.
There were no deficiencies
Oh, there
on
were.
lot 3,
I see.
which never reviewed.
Well, he said August, which made me think of lot 1.
Yeah.
Okay, so
Lot-
from the time of the initial application, how long did it take to report back to the for architecture firm or whoever, that there was a deficiency?
That,
Stuart, and for all the board, it would be really helpful if you said your questions directed to lot 1 or lot 3.
Okay, for lot 1, from the date of initial application, how much time lapsed before deficiencies were reported to the applicant?
it was submitted the last week of August, and the deficiency list went out, mid-December.
Mid-December. So almost 8 months went by after the deficiency report was sent and before the permit expired.
Okay, so August application, December deficiency report, correct? For lot 1?
Give the applicant to respond to the deficiencies.
I'm just trying to understand how much time was used by the various departments, Pitkin County, the environmental, all those groups, to respond to the initial application and report deficiencies.
4 months.
4 months, okay, thank you. And same question, lot 3, from application to report a deficiency.
Well, we never had any deficiencies for lot 3. It came in and was immediately put on hold pending land use approval.
Yeah, so in September 16th of 22, the intake is accepted. That's when the clock starts ticking. On 10/7, so in October, we put the building permit applications, all 3 of them, on hold, awaiting the resubmittal of the new access permit.
Referring to lot 1, from the time the deficiencies were reported in December, I think you said, typically, how soon do applicants respond to that deficiency letter? If you just give me some color of what would be expected, when would you expect to get answers or movement on deficiencies? And in this case, can you describe the first substantive efforts to cure deficiencies for lot 1?
Yes, I pulled that information anticipating you might ask. So I looked back last year, we had 16 single-family residence permits issued. The average staff review time for round 1 was 11 weeks. And typically when it comes back in, we prioritize those permits because they've already waited in line once. So we try to get our comments out in a week or 2.
I think his
The
question,
average-
I think his
Well, I
question.
just wanted to,
Okay.
the average time for the applicant to respond is 4.5 weeks from round 1 comments. And that was across 16 single-family residences.
And is there an average cure time for deficiency?
You mean for the applicant to cure it?
Yeah.
4.5 weeks. Usually
Oh.
people get it done.
Cure 4.5 weeks. So it's not just response, it's typically, these are typically issues that can be cured quickly. Is there, referring to lot 1, the deficiency orders, in your opinion, what is the time frame that would be appropriate for curing those specific deficiencies?
Ooh.
There was 10 deficiencies. and
There were, but
multiple-
there were 2 big deficiencies, I guess. I don't know if you want me to get into that much detail, but basically when we went back through all the staff emails, there was a lot of discussion from January to March. And then the last email in March was basically the green light. We've reviewed the new plans. This all looks good. And the architect responded, okay, we'll get these drawings together and resubmit ASAP. And then we didn't hear anything after that.
Okay. So the drawings, the adjusted drawings would have cured the deficiency. What was the date where you received that sort of, okay, we understand, we'll redo the drawings and get them back to you?
Yes, like I mentioned, there was 2. So there was one with Open Space and Trails and Aspen Valley Land Trust. And that was that the conservation easement, there were discrepancies between the easement and the land use approvals. And that came out in November. Immediately Open Space and ADLT was brought into the loop, and In February, they basically gave them the green light. They provided the draft easement agreement that was reworded to align with the land use approvals. And then I believe the final draft was recorded in April. So that was one of the big deficiencies. The other one was related to exempt below grade space and floor area issues. And that was what our staff was working with them, our zoning staff, in March. And on March 29th, they said, yep, what you've done here works. So proceed.
So I guess I'm confused. Doesn't that cure those two deficiencies?
Well, we just needed the new construction documents. They had a,
And you never received them?
correct.
Okay.
In order to move from round one, all of the deficiencies should be submitted as one document, or all the deficiencies at one time, resubmitted in stages. And that makes the clock start ticking back on our end for our review, and that never happened.
And referring to lot 3, there were no deficiencies, is that correct?
Correct, we put the permits on hold, and Leslie's here, she's more in tune with lot 3.
Yeah, and why would those permits be put on hold if there are no deficiencies? Why, I'm not familiar with the process. If there are no deficiencies, why wouldn't that permit have been issued?
We allowed the building permit application to come in so that the applicants they wouldn't lose their vested rights. With the understanding that their access issues would be taken care of, their land use issues would be taken care of with Leslie. And that never happened. So the hold was never released and it never moved forward to review.
So, we have been working, this is Leslie Lamont, I was the staff planner, working with, the team, the consulting team on this. And it was flagged early in the summer of, 2023, right? 2022, that, the access to lot 3, which was in a very specific, access envelope, was not gonna work. It was just gonna be too difficult. It was gonna be too harsh on the land. So we started working with the applicant as well as Aspen Valley Land Trust and Pickens County Open Space Trails to create a new driveway alignment to lot 3. And the new driveway alignment was going through the conservation easement, so that's why we had to pull in ABLT and OST. So in July of 2022, Mitch Haas submitted an amendment to a development permit, which is our language for he was submitting an amendment to amend lot 3 and also create a new access envelope to lot 3. So he submitted the application in July. We accepted the building permit application for lot 3 in September because they were running out of room within their vested rights period, their 20-year vested rights period. And so we accepted the application, found the application complete with the old driveway access, knowing that everybody was on board to amend the new driveway access. So Mitch submitted the amendment for the driveway in July. We issued an administrative decision in October, the end of October, for this new alignment for access to lot 3. The final action that needed to happen from Pickens County's end is we needed to work with the applicant to record a new activity envelope and site plan, which is the map that reflects what was approved. And that activity envelope and site plan was recorded February 1st. At that point in time, the applicant was free to pursue the building permit application that had been submitted in September. I got an email at the beginning of July 14th, I think it was, middle of July, that said, we're struggling to make our development work within the confines of the activity envelope of lot 3. We need to amend the activity envelope of lot 3. And
So
that,
so this was the activity envelope had been approved. There was really no holdup on anything and the applicant wanted to go revisit the envelope. Is that correct?
after we approve the new driveway alignment,
Yes.
yes.
So could the applicant, have pulled the permit, or I don't know what the term is, but I'm still a little confused why that permit expired. It sounds like that permit was approved, deficiencies, cured, or there weren't any, the envelope had been approved. Can you just be specific on why that particular permit expired?
Lot 3, there were no reviews. None of the referral agencies, the building department didn't do a review. We held it up front. We allowed them to get in the door so they didn't lose their vested. And we said, hold on a second, you need to have land use approval first. We did them a favor by allowing them to submit for building permit application.
Right, but what specifically did they need to do so that lot 3 permit would not expire? I realize the time is ticking. What action did they fail to take that would have prevented the lot 3 permit from expiring?
The activity envelope and site plan was recorded February 1st of 2023. They should have told the building department, we're pursuing, here is our amended admin decision, here's our activity envelope. You have our building permit, we're ready to roll on our
Yeah,
building.
but the building permit had old drawings. I mean, they needed to submit all new construction documents.
Okay, so
Showing the
is
new-
that the failure? They failed to submit new drawings
Right.
were consistent with the new envelope? Is that a true statement?
That's correct.
Yes.
We never released the hold because we never got the new documents.
And when did you, I'm just trying to build a timeline here. When did you communicate that for lot 3, the final requirement was those new documents?
Well, the day they came in the door, they knew the documents they were submitting weren't what they planned on building. And that was kind of how we met them in the middle, you know, I mean, we agreed that the new driveway alignment was better than what had been previously approved. And we didn't want them to lose the vesting on the house while they went back through the land use process to get the new driveway. So we brought it in as a placeholder and put it on hold because we weren't gonna waste all our referrals time reviewing something that was just gonna be completely changed. But.
Okay, so let me just summarize. Lot 1, the failure was to the permit expired because they failed to cure the deficiencies in a timely manner. Lot 3, they failed to submit the updated drawings that included the new envelope. Is that correct?
Yeah.
That's a good summary. Yep.
Yeah,
Okay. Sorry to someone
No,
else.
that's-
I have a question for the board, especially contractor Greg Woods and that. Have you ever heard of this happening before? I've heard of plans, people saying we're not ready yet. But I've never heard of it being a project like this. I mean, I don't know all of the projects, you know, but I know the building codes, so. Greg, have you ever heard of it?
So we deal in the contracting side, specifically, you know, once the project started, the permit's been pulled, that we know we have a 6-month duration to call in an inspection, or the permit could become voided out. So we're very hypersensitive to that direction once the permit's been issued. But before the permit's been issued is a little different for the GC side.
It's like,
Before we get into, sorry, Tom, before we get too much into board discussion, I think it would be appropriate to let the property owner and appellant present their argument so that the board can consider that before too much board discussion gets going on, if that's okay with you.
That makes
I
sense.
think if there's any other board questions to staff to clarify the timeline or anything, that would be appropriate to ask right now. But otherwise, it would probably be best to move on to the appellant's, presentation, if that's okay.
That's
And
good.
if the appellant disagrees with the timelines, I'm very interested in that, so let's hear from them.
So,
Yeah.
anybody else on the board that has question for, the building, the staff before we go to the appellant?
I have one question. Were any deadlines given by staff to the applicant to submit or lose out?
Yes, we have a very robust pre-submittal process that people go through. There's a meeting with the permit coordinator, zoning, engineering, possibly building. They could pull in other people as needed. And they go through the whole permit application. There's like a 43-point checklist of things that you may need or are not applicable, and they make sure that the permit is issue ready the day it comes in. During that discussion, they talk about the 1-year time frame to issuance. I actually, during the core request, saw an email from our permit coordinator after the deficiency list went out in December, where the architect asked, how much time do we have to turn around these deficiencies? And her response was, you have 1 year from the date of intake to get the permit issued, or it expires. So they were reminded again.
And from your notes, can you just state who the architect was in that discussion and who the city employee was that conveyed that information and the date of it?
Yes, it was Louise Mendez and Christy Long, our senior permit coordinator. And it was on December 22nd, 2022.
So I have a follow-up question.
Okay.
At any time did Pickens County espouse their opinion that this application was not being pursued in good faith?
To the applicant?
Correct. That the applicant was not acting in good faith, and therefore it would be abandoned because as I read the statute, they have 1 year unless they're pursuing it in good faith. So was there ever a determination made and told to the applicant that in their opinion, this was not being pursued in good faith?
No, we did issue 176 building permits last year. So it's a lot to keep track of. Our system automatically expires in 365 days after intake. I did pull some numbers about abandoned permits if you guys are interested in hearing that. But no, I mean, there's definitely permits that come up that we're aware of, you know, and like, oh, fire had that, or we had to go back to zoning because of something that changed at the building review. And those will jump on preemptively and extend them based on how much time they were held up somewhere. But I mean, this we haven't heard from for months, so it just expired. And they checked in September on the access permit that the access permit for lot 1 was approved and just waiting for them to sign and pay. And that's when their permits had all expired.
I guess I gave the Stu, go ahead.
So, question for the assistant county attorney, is the definition of, the phrase, you know, for actively pursuing it, in good faith, is there a definition, or is that led to the discretion of the zoning staff?
The latter, there is no definition provided. It's a determination made by the chief building official.
And is there an obligation if it's in good faith to extend, or is that at the option of the building official?
I think the chief building official has the option to make a determination that the applicant has been pursuing the permit in good faith, and if that's the case, the chief building official may then provide an extension.
Okay, may, but isn't obligated to. Is that correct?
I think
The
that's
discussion here is really simply to determine whether there was good faith or not. And I guess as a secondary matter, if we were to determine there indeed was good faith, do we want to grant an extension? Those two items?
I think from a matter of practicality, if there was a determination that the application was being pursued in good faith, it would then be difficult to say that there should not be additional time granted to pursue the permit.
Okay, thank you. Let's hear from the applicant, but I also was interested that one of the staff members commented that the permit was ready and all that was required was to sign, pay, and pull. Did someone say that?
That was for the access permit.
That was for lot one access, yes, that was approved. And a lot of times that,
And did that never happened?
no, they reached out in September and asked if they could get an extension on the access permit, and the permit coordinator said, well, all these permits have expired. Are you aware that your building permits have also expired?
Okay, I think we should hear from the applicant and then we'll have a lot more questions.
First, anybody else from the board in this line of, to direct things to staff? I have one question, which is, amongst all this, to your knowledge, and we'll hear from the applicant's knowledge also, was there a disagreement on design feasibility or what the applicant wanted compared to what was allowed by all of the codes?
I'm
In other
assuming,
words, was his design permittable?
I'm assuming we're talking about lot 3.
No, I assume we're talking about lot one.
Okay, let's talk about both, but anyway, or individually. I mean, is there something beneath this? This is a lot of procedural stuff, but is there something beneath this that says we don't like your design, or that, and we'll hear from them also, we don't like your rules? Is any of that going on?
No, the comments on lot one were pretty straightforward, black and white. And by March, they had worked through that with the zoning officer and everybody said, yeah, this is good, please proceed.
Okay,
And then the same with the conservation easement, that had also been worked through, so we were expecting a reason.
okay, so Phil, we turn it over to the,
I think that would be appropriate.
Thank you very much. Good morning. My name is Jenny Johnson. I'm general counsel for Barrett Door, which is the owner of this property. Mark Grochon is the owner of Barrett Door. And so, when he's speaking to you, it's as the owner of this property who's trying to accomplish this project. We also have Kaylani Jensen. She's his full-time architect who oversees this project from their office in California. And I have Luis Menendez, the architect of record on this case, and Mitch Haas, who is our land use planner consultant. I'm going to let you hear the facts about how this unfolded from the actual experts. Because they lived it, they can tell you about the facts, they can tell you about the conversations, they can tell you about all the good faith efforts they were making to navigate what is a much trickier project than a standard single family residence. The idea that, response times on a single family residence could be what would be expected in a project of this complexity with conservation easements and vested rights and lots of different overlays and the use of the 2002 building code, that's not at all a fair expectation for what anyone could accomplish in this project. But I would like to start you with looking at the law, because I think some of what you've been told about the law is actually materially incorrect. And so I want to explain to you how I believe the law works and put on my law professor hat, which is, what I do when I'm not helping Mark, and walk through some pretty basic legal concepts that I think really need to guide your evaluation of the facts here. So Kaylani, if you could put up the statute language for us. The code that you're looking at, really it's one relevant sentence. Next thing, please. And it says that the application for the permit shall be deemed to have been abandoned 1 year after the intake acceptance date, unless such application has been pursued in good faith. So it's not optional. It's not in the building official's discretion. It doesn't say, you know, it's deemed abandoned 1 year unless the chief building official in his absolute discretion determines an extension is justified. That's not at all what it says. It says unless such application has been pursued in good faith. And if you find that the application has been pursued in good faith, then that application cannot be deemed abandoned or otherwise over. We get to continue working through the process in good faith, as we always have, to be able to move forward with this building project. Now, there's a very basic rule of statutory interpretation that I suspect Bill knows well, which is that you give meaning to all the words and phrases in a statute. You can't render any part of the code language superfluous. That's what courts do when they're looking at this. They say, oh, any interpretation that renders language superfluous has to be incorrect, because language in a code is there for a reason. And here, the language, unless such application has been pursued in good faith, would be rendered superfluous by the chief building official's policy that is unspoken, unwritten, never told to any applicant ever, that they only extend building permit applications beyond the 1 year after acceptance date if somehow they're the ones at fault or their reviewing agencies took too long. That's never been communicated to anyone ever, as far as we know. And, you know, our professionals work in this space regularly all the time and have never had a permit application deemed abandoned when it goes beyond a 1 year period. So as we're looking at this, you think, okay, well, what's the next question? What does good faith mean? What does it mean to have pursued a building application in good faith? And this code provision doesn't define that. It's not anywhere in this code. So Colorado courts, when the specific code doesn't define it, look to the definition of good faith in Black's Law Dictionary. It's a very common source of, you know, what does a legal term mean? So Black's Law Dictionary tells us that good faith is a state of mind. It's not a series of actions. It's not a, you know, actually successfully meeting a deadline. It's a state of mind consisting in honesty and belief or purpose, faithfulness to one's duty or obligation, observance of reasonable commercial standards of fair dealing, an absence of intent to defraud or to seek an unconscionable advantage. It isn't results oriented. It doesn't say, if you didn't actually successfully submit plan drawings by an arbitrary date selected by the building official, you weren't acting in good faith. This is about the state of mind with which an applicant is working toward permit approval. Now, because it is a state of mind, and you know, most of us don't claim to be mind readers, the courts tell us how to evaluate good faith. And they say what you do is you look at all the relevant circumstances and you draw reasonable inferences from them. Well, all the relevant circumstances usually involves actually talking to the person whose good faith you're evaluating and communicating with them about, you know, are you still pursuing this permit application? What are all of the efforts that your professionals are going through right now to try to accomplish, you know, the goals that we gave you in a deficiency? What are the hurdles that you're facing as you go through that process? There was no communication here at all about whether we were in good faith, what our professionals were working on, and you'll see that they were working on quite a lot. Any indication from the county that they didn't think we were working in good faith or that we were up against any kind of deadline whatsoever. When you actually hear about all the relevant circumstances, you'll see that Barrett Door and the many professionals it hired pursued these applications with honesty, faithfulness to duty, with the highest regard for standards of fair dealing with the county. And there could not be any allegation that they intended to defraud or seek an unconscionable advantage. And I haven't heard one ever from county staff. I don't think that's an issue we have to deal with. I think the issue here is the county staff applying an incorrect definition and understanding of good faith. and what the provision of this actually means. I also think we have a materially different view of what it means to observe reasonable standards of fair dealing with each other. Because you will see, as Mitch and Louise talk about all of their interactions with the county, that they pursued the most open communications, trying to facilitate meaningful and efficient progress. They, after the deficiency notice in Lot 1, requested a meeting to try to understand what the comments meant. They submitted concept drawings to make sure that the county approved the concept of how they were going to redesign the CDU, worked through getting those approvals, and had all of that in the process of redesign and reengineering. We raised the issue of, hey, we can't build in the activity envelope that was pre-approved on Lot 3. That doesn't make any sense at all. Let's work together to fix this problem we inherited when a conservation easement was poorly drafted. And they spent countless hours working through all of these issues, telling the county exactly what they were trying to achieve, that they needed to preserve the vested rights on the property. And that's a term that you've heard a couple of times that I imagine not all of you know what that means for us and for our property and why this is so important. This isn't just kick us back to square one, make us pay another review fee, and we start over. We have really important vested rights on this property as a result of the conservation easement that was put on it long ago and site plans that were approved in concert with the granting of the conservation easement. We get to do up to, I think it's 4,000, and Mitch or Louise can tell you, square feet of below grade space, having that exempted from the living area requirements. They're much lower because of the conservation easement than they would be if we were under current building codes. So we really get, if we lose those vested rights, we get kind of squashed in the middle of an unfavorable building code and not getting the rights that were granted to us to kind of help alleviate that unfavorable building code. So those vested rights are incredibly important to our ability to build buildings on these lots.
Can I jump in?
Yeah, of course.
So you are at risk of losing vested rights.
Yes. We are at risk of having our vested rights lost and deemed abandoned because somebody made an arbitrary decision that we weren't pursuing permits in good faith without ever asking us what we were up to or giving us any warning whatsoever. In an effort to avoid repetition and keep this as concise as possible, I'm going to have the people who are really involved talk to you about the details. But as you listen, please keep in mind that the code contains this language that extends the time for people who are pursuing their applications in good faith for a reason. There are projects like ours that require coordination with multiple agencies, easement holders, many busy consultants who have specialized expertise needed to design and redesign. And, we go back in the queue. When we have to redesign a project, we get back on their waiting list to get the civil engineering drawings done and the electrical engineering drawings done. And it's a process and it takes time.
But what I mean by, let's go back to this, vested rights beyond your building permit.
The vested rights had a set period of time where we had to file a complete building permit application by a deadline in order to maintain those vested rights.
Yeah.
So if we didn't get a complete building permit application in by a deadline, we lose them. Yeah.
Do you have property rights that come from some other place? That's,
Yes.
and what is that?
Mitch will explain that when he talks, because he can explain that in a lot more detail than I can. I'd be giving you my, not even land use lawyer answer to that, and that's not fair to you. I'd rather have him give you the full answer to it. One more final point from me before I hand things over. We've never abandoned the permit applications. Barrett Door paid over $1.4 million in permit fees alone and was spending in excess of $130,000 every month during the period that these applications were under review on the consultants who were working to get these permit applications approved. So the idea that we abandoned or we weren't working in good faith really is pretty absurd with the amount of spend and effort that was happening every single month while these permit applications were pending. Good faith is a two-way street. We gave the county lots of it and we didn't get it in return. First, Mark is going to make a brief statement about his intentions so that you can all see that he's been acting in good faith all along.
Council, can I ask a quick question? Just something you said. At some point you said that you weren't aware of any deadline whatsoever. Maybe I took that the wrong way. Is that your contention that that the group had never been informed of deadlines?
That's right. There were no deadlines for getting responses in because we were operating in good faith the whole time. And when you're operating in good faith, the 1 year from intake acceptance doesn't apply. And there weren't any other deadlines.
Okay, so it sounds to me for the rest of the board, what we're really talking about here is what's the definition of good faith. So that's what we'll be exploring. One other thing for council, you use the phrase countless hours and you've mentioned $130,000 a month. Have you brought evidence through billing or statements from architects, planners, consultants and such that shows the amount of time that the applicant was putting into addressing these issues?
I don't have those detailed billing statements. I do have, the summaries where I know how much spend was going out per month and I know who it was going to, and it was the people who are working on these permit applications. If you do need more detail about that number and it, remains material to you after you hear those people talk about all the work they were doing, I'd be happy to pull something together for you.
Okay, thank you.
You're welcome. Any other questions before Mark speaks?
Anybody?
The one thing you mentioned, the UBC code,
Mhm.
and I looked up the code in the 2018 UBC code because I couldn't find the old one. And it specifically says 6 months, or they can grant an extension of 3 more months.
I can speak there. It's the IBC, the IRC is what is applicable, the International Residential Code.
Yeah,
We've amended that section, so we amended it to link them to 12 months from 6 months.
yeah,
And then we added in the pursuit of good faith. So the pursuit in good faith is not code language that is in the IRC, it's Picken County amended language.
but you amended it because the hard time finding contractors and people, that was, I think, your reason for doing it, or?
It's been that way for a long time, and I think we amended it because our process is a little bit different than other jurisdictions. It's a lengthier process, and it gives applicants a longer period of time to get their permit submittal documents and get all their approvals.
Yeah. I just wanted to clear that up.
I have a quick question. For clarification from the county, when permit comments are issued to an applicant back, is there a date stamp on there that says you have until X date, whatever that is, 12 months down the road on when permit comments are due back, or your permit will become null and void, or your application will become null and void?
No, there's just the overall timeline of a year.
It's
But-
not on the
Is there
report.
something that defines the start date of that year review?
In the code section, it says intake acceptance date.
Correct.
1 year from that date, the permit will expire unless it's been pursued in good faith.
So I think that's part of the reason we have such a thorough pre-submittal period, because we want to make sure that permit's ready for all the reviewers, right? Like the better it comes in, the more efficient we'll move through the process.
So the initial intake date is deemed, must be completed within 12 months from that date, even if there's a round of 2 or 3 or 4 or 5 back and forth with comment reviews.
Correct. There could be multiple rounds.
Okay, I'm not sure if that's ever been clearly identified. Maybe it has, but I've been building up here for a long time and I've never really asked that question because it hasn't become an issue, but I see that as somewhat of a gray area.
This is something, again, that we go through, and that's why we hold a pre-submittal meeting, and we go through all these documents with the applicant and with their understanding that, the code sections that are applicable, it should be well known after permit submittal.
I would just add that we went through that pre-submittal process with flying colors, and they found our applications complete and thorough and accepted them as complete. And of course, Luis Menendez, our record architect, knows this code provision, and he knows very well that as long as you're pursuing the building permit application in good faith, there is no strict timeline. And we were pursuing the permits in good faith at all times. So to act as if we had noticed that there was a strict 12-month timeframe, that's crazy, because it's not what the code says. And it's not what any of the professionals who work in this area on a regular basis understand the rule to be.
You're relying on the good faith, in which case you would have more time, correct? So it's an issue of good faith or not good faith. I think that's the core issue here, and you will be attempting to demonstrate good faith. And I will ask the city staff who, for a living, issue permits. I assume that they want to issue them and get them off their desk, why they view this as not a good faith effort.
Thank you. Okay, Mark.
All right, I'm Mark Rochon. I own Barrett Door. Before I read this, I wanted to say that to kind of answer one of the questions in terms of the vested rights, and what we lose is we lose the 4,000 square feet of basement space, and we also lose a 750-foot garage. What right now I'm allowed to do with the vested rights is build a 5,000 square foot house with 750-foot garage and basement. If that is taken away from me, I will completely have to redesign these buildings. Both buildings incorporate a design or a garage. It's one of the reasons why this is super devastating. So I am the owner of Barrett Door. I'm an artist. I'm not a developer. I have never tried to slow walk this project. I have only worked cooperatively with OST and with AVLT and the Snowmass Caucus. And my team has always worked with Pitkin County in good faith. I bought this property from the Child family in 2016 and have been trying to build on it ever since. The process of designing this project, seeking approvals, redesigning to address concerns, and navigating a conservation easement has been long and challenging. At every turn, I agreed to requests from the county and propose mutually beneficial solutions to problems created before my time. When we discovered that the approved access lot 3 would have required a monstrosity of a retaining wall, smaller. We worked with the county to move the road and the driveway, which would also require moving the buildings. The proposed, it wasn't just a proposed, it was issued by Pitkin County, that driveway. That was just not safe for fire trucks. That is why we moved this thing. Knowing we were up against the deadline for preserving my vested rights on the property, we sought guidance from the county and were told to submit complete building permit applications with the old driveway, and the county would put them on hold and allow us to amend the plans after approval of the new access plan. I was blown away and I was devastated to hear that our permit applications went from on hold to abandoned with no notice while we were actively working through these issues caused by the driveway location. You guys broke me. You did. You broke me. Whether that was your intention or not, that is what happened. My team was talking to the county staff constantly, up to and including the day the chief building officer took away my rights by declaring the permits expired. I have at all times pursued this project in good faith. I have 3 full-time employees dedicated to managing this project, including a licensed architect. We chose experienced, highly regarded local professionals. I am personally in regular contact with everyone on the team. It's hard for me to imagine what more I could have possibly done to pursue these building permit applications. I have poured my life into this project. I never dropped the ball, and the team never dropped the ball.
Thank you.
Thank you. Thank you, that was nicely spoken. Would anybody else from the Mark's team like to add to anything?
Yes, we actually have quite a bit more presentation planned for you. We will try to keep it as brief as we can, and respect your time. Kaylani, why don't you introduce yourself, explain who you are, and then we'll fly through some overview quickly.
Can I make one, I have a hard stop at 12. Just want to make sure that that's known.
Thank you for that.
We'll breeze through. So all of these visuals have been sent to all the board members and county staff. I think that everyone has this information, so I'll just breeze through it. But I'm Kaylin Jensen. I'm the full-time project manager for Mark. I manage 2 staff members, and I'm a licensed architect in California, not Colorado. But primarily my experience is in high-end residential custom homes. That's my expertise. There's 21 different consultants on this team for this project, and I manage all of those people. So we put together some images to help you understand the project, just to place make it. This is a 1,300 acre ranch that has most of the property is conserved land. So you can see on our site plans how small an area that we're actually talking about here. And the areas in question are lots 1 and 3, which I've showed as an aerial simple diagram. We can pop back to any of these at any point if you guys have any questions. So what we'll go through is the response for lot 3 realigned access road and the lot 1 CDU deficiency response. Those are on the left side of this screen. And then on the right side are the lot 3 2002 approved access road and the lot 1 CDU 2022 application. So you can see that the responses to deficiencies in the case of lot 1 are indicated here. And then also the mutually agreed upon approach to realign this driveway, which can be better explained by Mitch, who is spearheading this conversation with Leslie and Larissa as part of a land use approval. I put together timelines of the events. I think that there's been a lot of questions here about what actually was happening during the time we were in our permit process. So I won't go in detail, but just to explain the general logic of these timelines, this is the simplified version, which just shows the primary milestones from when we submitted or maybe a little bit before, and then until we were deemed abandoned in September of 2023. And so the bottom part shows building permit, access permit, any like agency coordination. And then the detailed timeline shows any particular meetings with staff that we had, and any timelines that we on the consultant team had to do to address concept design, schematic design, design development for a full package of construction documents that we wanted the staff to review and not waste anyone's time with something that wasn't complete. So for lot 3, there was a lot more administrative approvals and involvement, so there's a lot more milestones here. And then you can see the timelines, the dates are all listed here. We can flip back to these at any time.
And I'll just interrupt for one quick second to note that all of this was included as exhibits to the written submission that should have been included in your board packet. So the lot 1 timeline is exhibit C and the lot 3 timeline is exhibit D. So if any of the board members want to be able to study those timelines, even when they're not on the screen, that's where you'll find them.
Was this created for this meeting, or was this a part of your internal documents that you were using on the project?
This timeline was created for this meeting, for presentation, but there's a project log that was included as Exhibit E that was kind of maintained in the regular course of dealing with the county. And, you know, these events are reflected on the project log, and there's more detail actually kind of in the project log.
One clarification, the pre-application, is that prior to August?
Yes,
Okay, so
Yeah.
it was deemed complete and officially submitted August after the pre-application process.
that's correct.
Okay,
And is it accurate that from that August date then that everyone's agreement, there's a year timeline unless everyone is acting in good faith? I mean, I'm asking if for the city staff, is there any disagreement with this timeline? I know there's a disagreement whether there was good faith activity or not, but is this timeline accepted? I want to make sure that there's no alternative fact on timelines.
I mean, there's a lot of this that we weren't privy to, like the Army Corps of Engineers stuff that we
Yeah, this
weren't
is all-
involved with at all. I mean, for us, the timeline is just the first half of the page. Yeah, so I think kind of just to jump in, what's like important to note is that I think that there's many agencies, as you guys know, as people that work in building, there's a lot of agencies involved that are county staff, there's Army Corps of Engineers permit, like for example, the new road had to cross a wetland, like a small part of that. And we needed to go through a state permit process in order to make sure that we could return back with our access permit that was complete. So that was one thing, like that's another agency. We also did a lot of coordination with Roaring Fork Fire in conjunction with lots 2, 4, 5, which aren't subject matter for this hearing. But that process was also done, not, you know, with you guys copied, but that was done with Brookstop with our civil engineer primarily. And so we had to modify our access permit for lot 1 because of the deficiencies, which Luis can go into more detail on as architect of record. But we had to modify our access for lot 1 because of the redesign of the CDU and ad building that the county gave us the okay on in March of 2023, end of March.
So in sum on that, you know, there are things that are outside our control that are also not within the county's control. And so, you know, when they articulate their policy that was never told to us about how they'll extend that deadline if it's taking their coordinating review agencies a long time to put the ball back in our court, there are other government agencies that have to review things that take a lot of time, that are now outside our control, that they're not considering, like the Army Corps of Engineers and how long that took us. So there's a lot going on here that is not within our control, that makes this process take a long time. Is there anything else before we turn over to
I think
Luis?
we can get into Luis's portion now for lot 1. I know that there are questions about the deficiencies and what was needed to respond to that, and so he could bring that up.
One thing, we have one of our board members, I'm not sure what time it is.
11:20.
I see it now, okay. We want to make sure that Sarah can hear as much as possible before she goes. So, or anybody else that has to, Leslie, so, you know, give us the good stuff
I'll speed through it as best I can. I'm Luis Menendez, a local architect in good standing. I've been practicing architecture since 1983 after graduating with a 5-year Bachelor of Architecture degree from a prestigious architecture school. And I've been practicing in the Valley since 1994. I'm licensed in Colorado, California. I also hold a general contractor's license and I'm a member of the American Institute of Architects. Aside from our residential work, we've done a variety of projects for Pickens County, City of Aspen, and other local governments. We have a reputation for being meticulous and thorough in our work. It is rare that our projects are not deemed complete and accepted at the first pre-submittal meeting, as was the case with these projects. I've had many of those meetings, and not once have I been informed that we have a hard 12-month deadline. And if you're informing other applicants that that's the case, that's incorrect because that's not what the code says. Most plan reviews yield few comments requiring corrections on our part. Most importantly, we have maintained an excellent and collaborative working relationship with community development staff throughout my entire career. What occurred to us on this project is unprecedented. In my 40+ years of professional practice, I have never had a request for a meeting with a public official to present material to assist the official in making an informed decision be rejected and a plan review process terminated without just cause. This has been very upsetting. My role in this project is of the record architect. There's a separate design architect from out of the country. Together, we've been working on this extensive and complicated project since 2019. Regarding the deficiency report, since Mr. Erickson cites the deficiency report in his response to the appeal as containing 10 zoning deficiencies, as if that somehow represents an unusual number of deficiencies, I would like to point out that in fact, it only contained 2 legitimate deficiencies that required action on our part. I'd like to bring up those deficiencies and go through them quickly. I don't know if you can read them. They're on the screen, but comment number 1 came from zoning saying, after reviewing the conservation easement and land use entitlements that were granted in conjunction with the CE, I have a hunch that restricting a CDU to be attached to a resident and not a garage or barn, as per the CE, may have just been an oversight. This is not a deficiency on our part. This required action on the county's part. And it was a hunch on the zoning officer's part that perhaps the Board of County Commissioners did not know what they had approved. So he delegated this back to Aspen Valley Land Trust for an opinion. We had followed clearly what was noted on the land use approvals, which was to attach a CDU to a garage or to an agricultural building. This robbed the project, this process, which took from the time the deficiencies were issued in December 13th of 22 to a final decision from ADLT on April 19th of 23, robbed the project of an additional 4 months. So it was 4 months to get the deficiencies, 4 months for ADLT to render a final decision. Comment number 2, accessory structures may not have exempt below grade space per BOCC resolution. There was an interpretation question regarding below grade space on the residential use that is not principal residence. Following a meeting with members of the planning department to discuss the old code, because this project is as part of the old land use code and part governed by the new land use code. So that created some confusion. This necessitated redesign of the CDU structure. There was also a question about whether the breezeway that connected the CDU to the agricultural constituted a connection. To avoid any possible future issue, we agreed to remove the breezeway connection. So that was a legitimate deficiency that we began to address. Comment number 3 was to include scale on all sheets of building and civil plans. That was an easy fix. I personally reviewed the architectural drawings. Anything that required a scale indeed had a scale. So I don't know why they included architecture as part of the deficiency. There were a few sheets on the civil plans that the scale number had corrupted during the printing process or converting to a PDF. And the date was not legible, but again, it was an easy fix. Comment number 4, CDU may not be more than 1,000 square feet of net livable space. This was not a deficiency because the CDU represented met that criteria. It was not greater than 1,000 square feet. Comment number 5, please include attic and space above restroom and closet in FAR calculations for main residence. This too was not a deficiency because the attic that they referred to did not exceed 5 feet 6 inches in height, which makes it exempt from floor area. Comment number 6, materials used for exterior of the structure must be native, non-reflective earth tones. Will the roof be reflective? Also not a deficiency because the information was included in the submittal. The submittal included images of all materials, including non-reflective roofing materials.
It's essential.
Can I just ask a question? You've gone through several deficiencies and stated that they're not deficiencies. I would think the obvious process would be engagement with the city staff on how something was labeled a deficiency as opposed to, trying to cure that. It sounds pretty straightforward. Can you tell me about the process for, looking at a deficiency, your view that they were not deficiencies, how you resolve that, including any dates for example, let's take the one about the attic height, just as an example. I have no opinion about attic height. So that is a very technical question for the staff and you on what date was there a response to staff saying that they perhaps had issued an incorrect deficiency or at least opening the debate on it? Do you have that date or that email, or I'm just curious. I'm trying to understand the process here.
In the interest of time, then I will only focus on those deficiencies that required action on the county's part and not ours, because I'm hearing that they're putting the burden on us to respond to deficiencies, yet it took them months to respond to deficiencies that were on their plate.
That's the kind of thing we're talking about.
Okay, so the first one I already mentioned, that was the one about ADLT. The other one relates to the agricultural covenant and the deed restriction. The zoning officer stated, ag covenants and deed restrictions for CDU are being reviewed by county. If they are not applicable, new ones will be provided by the county and should be uploaded with respective permits during round 2 review. We will update you as soon as possible if any modifications are required or if the ones provided are acceptable. We're still waiting on a response for that. That information was never provided. So I don't know how they expect us to resubmit for round 2 when we still don't have the information that they need to provide. Given the combination of all the new land use codes, multiple land use approvals, a conservation easement with its own set of requirements, the complexity of the project with multiple buildings having separate design and record architects, any design professional would have expected more than just 2 legitimate deficiencies.
Luis, would you comment quickly on the OWTS design? Because in Mr. Erickson's memo to the board, he said that did not have the required detail to complete the review.
Right, so in addition to the zoning deficiencies we just went over, there was only one other deficiency, and that was from environmental health, that the OWTS, that's the on-site wastewater treatment system, design submitted did not have required detail to complete the review. Well, the civil engineer addressed that, and it was permit rated on 3/15/23. The one deficiency that impacted the schedule was the need to redesign the CDU structure, but this was done expeditiously. Even before Aspen Valley Land Trust had responded with a decision regarding whether a CDU could be attached to an agricultural use, the design architect had already provided a conceptual design for the new structure and a new location. I requested a meeting with the zoning officer, Mr. Matt Benning, to present the new design on 3/1 of 23, more than a month before the ABLT issued a decision. I met with Mr. Benning on 3/7/23 to review the conceptual design. Mac felt the design was acceptable, wanted to take it to staff for their review as well. On 3/29/23, several weeks later, Mr. Benning responded that the design was acceptable and that we could proceed with the formal changes to the submittal. We immediately began scheduling all of the work that goes into producing an entirely new set of permit and construction documents. As all of you know, particularly those in the building industry, it takes time to develop a set of documents, especially given how busy consultants are and the challenges in getting on their schedules. Mr. Erickson also cites a response about potential additional deficiencies from the building department. In the interest of time, I won't get into that, but he was speculating. As a record architect, I can attest that at no time did we not pursue the permits in good faith. I was shocked to learn the project had been deemed abandoned. And when I offered to explain to Mr. Erickson how we had been consistently and diligently working on the project, the offer was flat out rejected. The precedent that Mr. Erickson's decision would set, if allowed to stand, together with the lack of a collaborative approach on the part of a public official, should be very alarming to all of us in the construction industry and anyone looking to build in Pickens County. I'll turn it over to Mitch.
Yeah, in the interest of time, unless you have questions for Luis, we will have Mitch address lot 3. Because he was.
Anyone have questions for Mitch based on any of that before we hear, on Luis, before we hear Mitch, who's the planner? Anybody? Okay, I think we're all getting this pretty well. Oh, sure.
Not right now.
Oh. Okay. Mitch, we're looking at you.
Thank you. Good morning, afternoon, wherever we are now. My name's Mitch Haas. I have a business called Haas Land Planning. I've been a professional planning consultant in the Valley since the middle of 1999. I've worked on, I don't know how many projects in Pickens County. I like to think I've earned a good reputation with the county over the years. Certainly I know that's the case as far as the county commissioners are concerned. I've never had anything like this.
We're here, by the way.
I've never had anything like this occur before. I've never heard of somebody in the county saying, no, we won't talk to you to hear your side before we make a decision. We made an overture and said, let us come in and show you before you render your decision how we've been working in good faith. And we were told, no, we're not going to meet with you. We're meeting internally and we're rendering a decision. I've never heard of that. That's so not Pickens County. That is not how Pickens County works. And frankly, I find it unprofessional altogether. But that's what happened here. So going back into a little of the history, we inherited.
But nonetheless, you are a planner.
Yeah.
And this gentleman's a building official.
That's right.
So you're not exactly on the same.
My request went to Leslie and was transferred over to Jeffrey, and we were told, no, we're not talking to you. We're going to make a decision. In fact, every time I reached out to Jeffrey, he never responded. Someone else did. But that's, Mark inherited this project from a 2002 approval that the Child family obtained. That 2002 approval came with 20 years of vested rights, which the county was happy to grant because they got a 1,300 plus acre conservation easement on the property and only 5 homes on a property that could have accommodated as many as 35 homes, given the state exempt subdivision rules. The county loved the Child Ranch project. Every project that came in, not every, but a lot of big ranch properties that came in for over the years was, why don't you do what the Childs did?
Everybody loves the Childs.
Yeah, well, but somehow, I don't know, the opinion seems to have completely reversed on that. But anyway, part of the approval, particularly with lot 3, had a access envelope that was approved, and that's where your access off Nicholson Creek Road to the lot was supposed to come through. How that access envelope got approved in the first place, I will never understand, because I wouldn't have even applied for that knowing the county's rules. The entire driveway access went through slopes well over 30% and could not be built to fire code standards without essentially designing a tunnel with no roof. The driveway was gonna have retaining walls on both sides of 19+ feet tall. It was an abomination. It's something that clearly the county wouldn't have wanted built, much less AVLT and county open space and trails running through a conservation easement. When we started to work on the permits for lot 3, because we knew the vested rights were coming up, we knew we had to get in a complete building permit application. It was discovered quickly that this driveway was gonna be a disaster, and not anything anyone wanted to see. Not only was it an eyesore and something that never should have been approved, but you couldn't build it without getting a Board of Adjustment variance first because of the work that had to occur in the setbacks. So I immediately reached out upon noticing this to the county and said, we've got a problem. We need to keep our vested rights. We have to get, I was perfectly clear that this was all very much intent because of the vested rights. We have to get in by this date. But we can't go change to a new driveway alignment by then because there's a land use process that has to occur for that to happen. Leslie, everybody in the planning office, the open space and trails department agreed, you're right, we don't want this driveway. Let's pursue a different alignment. So we went out and walked the property with planning staff, AVLT, open space and trails to figure out a proper new alignment. We all agreed it's got to go this different direction. Now we need to put together a land use application for that. That's not something that just happens overnight because you've got to do a site plan review for this driveway. So you have to engineer all the grading and the drainage and figure out that alignment precisely, figure out where the fire truck turnouts go, the whole thing. It's not just a line on a piece of paper. So that all had to occur. We put together the land use application, we submitted it. Meanwhile, I'm communicating and saying, listen, we have to get our permit in and have it deemed complete before the vested rights expire. Nobody wants this pre-approved driveway location to happen. Can we do something else to put the permit application in? Can we use the existing ranch road that goes up to the activity envelope as temporary construction access to allow us to proceed with our permits while we work out the new driveway? That was told, no, you can't do that. And I was not agreed to accept the application with the engineering of the pre-approved envelope. I was told you have to provide the engineering and designs for that pre-approved envelope, which no one wanted to do because that's crazy civil engineering design. It's like Glenwood Canyon type of design. But we did that. Meanwhile, I had an application pending. I said, look, we can't submit that building permit application with this because it requires a Board of Adjustment variance for the setback work. So we have to go get that first. Well, why? I was asked, why are you going to the Board of Adjustments? Because we can't submit what you're requiring us to submit without the variance first. So I went and got the variance. Then the design got finished and submitted with that driveway in it. Meanwhile, we were still working on the other alignment and land use approvals, which went into whatever dates were in the timelines. I'm not good with dates in terms of memory. We finally get through that process. It takes time to record the approved site plan because we had, I don't know how many back and forths about, okay, here's our drawings, no, change that, and I want you to show this. And so, I mean, it takes time. So eventually, as soon as we could, we got those signed and recorded. But the approval for the new driveway alignment came with a condition that before we submit for permit to the county for that new driveway alignment, we must obtain Army Corps of Engineer permits also. So that had to go on. That, of course, takes time. You don't just ask the Army Corps for a permit and they give you one. You have to prepare a proper application and the designs and show it to everything to them and the impacts. And then we got that permit.
Can I ask a question on that permit, just as a point of evidence? So I see you received it in June. Do you recall when you applied for that permit? I'm just as in, evidence of
We applied
on April 25th of 2023, and then we received that permit on June 13th
Okay,
of 2020.
thank you.
So anyway, it turns out the original design submitted for the permit, the driveway, of course, came into the center of the envelope from the old design, the old approved envelope. Once the new driveway alignment was done and approved, that comes in from the far south end of the envelope, not the middle. So changing that required moving buildings because the driveway comes in a different place, figuring out all the new grading, all the new drainage impacts, all the different measurements and heights and things like that. When you move the buildings, we were in that process still. And yes, we ended up needing to say, when we were doing these things and responding to the new driveway location and its impacts on the previous designs, it would be best, given that we were then gonna end up with a big retaining wall that no one was gonna wanna see or have to build. We needed to start moving a little bit, a minor amendment to the envelope configuration. And I was actively emailing back and forth with Leslie on that particular issue and discussion, literally still in emails that day when suddenly I was told, no, your permit's been deemed abandoned and expired. Put your pencils down. We were working in good faith actively that day, all the way up through that day on lot 3. I was floored. I was like, what do you mean not working on this? Well, so we immediately reached out and said, well, we'd like an opportunity to talk with you and explain, not only have we been working in good faith, we've been busting hard on this. I've never been in a project. Our group met twice a week, every week, to discuss what everybody's working on, how we're responding to this, how we're changing that, making sure that what we were putting together was going to work so that we could resubmit it all. Twice a week, this was ongoing throughout, from day one, even before we submitted, even through to the day we were told, no, you're not in it anymore. And we say, well, let us explain what we've been doing. And we were told, no, just issued. So we're left to look at it and say, you just assumed we weren't working in good faith because you didn't ask us. You wouldn't give us a chance to explain that. You made an assumption and pulled the rug out from under us. After we've been working endlessly at, I don't know how much Mark spent, but more than I'm worth, I'm sure, on this process, to have it pulled out from under us with no warning. So that's kind of where we went on that. And I mean, I don't mean it, I don't know where it came from. I've never had the county treat me or anyone I've been involved with that way, where they said, we're not willing to hear your side before rendering a decision. And that's kind of what happened here. Not kind of, it's exactly what happened here. So that's the gist of it for me. I mean, we were
closed with that.
throughout, we were working hard. We never once put our pencils down.
Can I, I'm sorry. Leslie, do you recall these emails and conversations that speakers talking about? Did they occur?
They were primarily emails. But Mitch is correct in his requests to me regarding amending activity envelopes. There were 2 amendments to the activity envelope that he requested. There was one amendment that we were able to adjust before we recorded the new driveway alignment as it was coming on to lot 3. So that happened before February 1st when we recorded the activity envelope and the site plan. Then we recorded the activity envelope and the site plan, and it wasn't until July that Mitch emailed me and said, oh, we're having a problem with fitting our drainage improvements on the lot. And we think we need to amend the activity envelope, and which is a perfectly legitimate request. People ask us to amend their activity envelopes all the time, but those are the things that are done before building permit applications are submitted. Those kinds of things and those kind of tweaks that we work out and we try and accomplish And I do want to say that we all were in agreement that this new driveway alignment was the better driveway alignment versus the old one. Typically, an administrative review to amend an activity envelope between when someone submits the application and we get everything done is, 6 to 8 months. And Mitch received the admin decision the end of October. I mean, we hustled on that. And then I just also, because Mitch is accusing us of not responding, when Mitch emailed me September 11th and said it's just come to our attention that last week we were told that a permit application, that everything was abandoned. He said, can we talk about this? And I said, it's in the building permit realm. It's not my realm. And building staff are talking about that.
Yeah, we specifically asked to meet with us before you render a decision. And we're told
The
no.
decision had been rendered a week before.
So is there any other presentation from the appellant?
No, we would just
Any
be
other
happy to answer any questions.
Anybody else with any questions for the appellant?
Was there
Dave-
ever a request to extend the vested rights?
Yes, I still have that pending and I've been asked several times to withdraw that request. And I said, no, I'm not withdrawing it until the permits are issued because I don't trust that we're going to get there.
For lot three,
So
for lot three.
for lot 3, yeah, I had asked to extend, but yes, I put in a request just as a placeholder because we didn't really feel like we were gonna need the hearing because the permit application was deemed complete. And I had been reassured in emails and verbally several times that we don't have to worry about that because our permits were still deemed complete. And that even after the driveway and the changes, we would not be required to do a new permit, but it would be allowed to be a change order. And I should mention that lot 3 was put on hold. Is a hold not stop the clock?
No.
Isn't that what a hold is? A pause button that no one ever released the, by the way, it's
Well-
still on hold
Well,
when it
according,
got, when it got.
according to you guys, there is no clock.
Exactly. There is no clock while working diligently, but still, I mean, you put a hold on it and never released the hold. So why was your clock still running? It's a rhetorical question.
There were multiple assurances all along. Go ahead.
Sarah, would you like to speak?
Me? Yes, and I'm sorry, you guys, we have 12 minutes, so I would request that we get into the Board of Appeals comments.
Yes.
I have something if I may.
Go ahead.
First of all, I fully understand there was a frustration with pace in here, so that's fine, that's what it is. My second observation is there seems to be a lack of respect between the applicant and the city staff, and that may be two-way, I don't know, but I would just urge everyone to take a step back here and be respectful, and let's examine the issues. My default is that the city staff work hard. Their job is to issue permits. They're not well paid. They serve the taxpayer, and I give them the benefit of the doubt. But I understand and I do hear the real frustration in this. I would like to ask the building supervisor and staff that since you've heard all this, before you ask us to get into a big debate over what good faith means, do you still contend, given this new information and the discussion, that there is a lack of good faith in this process? I mean, I just would like to ask, maybe you look at all this and you say, why don't we just step back? Maybe you've learned something today, and maybe if this group can agree to engage you with more respect, you could all work together and sort this out. So I just want to ask that question. If you feel that they have not exhibited good faith, and my question is, can you again, and maybe I'll ask Leslie, because I know specifically she's been engaged, why do you think this is not a good faith effort? But first I'll just ask, does the building supervisor want to stick with the contention or not?
Okay, so he's asking you guys, do you feel that you've been treated disrespectfully? And secondly, has there been a lack of good faith?
I'd just like to say I issued 176 building permits last year. 6 or 8 total were abandoned or expired, 6 of which we're talking about today. There's only been 2 permits last year. I have 170 permits that expired. So this is a nominal.
Wait, well.
Okay, but here's my specific question, just one question. Having heard this and seeing, listening to everyone, maybe it's the first time you've heard all this, we just set aside, I don't doubt that there's been some high friction back and forth. I'd like to set that aside. Is your contention now, at this very moment, that this group has not acted in good faith to get this project done? Do you still believe that?
Absolutely. Yeah.
Okay, so my next question is, Leslie, do you concur with that? I'm interested, you worked on it. I guess I'm trying to define good faith now. I just want to understand.
Yeah, the lens that I was looking at, specifically for lot 1, and I kind of want to take a step back here. I never received an email from Mitch Haas. I did receive an email to review the timeline with Luis Menendez. I reviewed the timeline. I just looked at my email. I don't have an email from you. Maybe it went to junk. I'm sorry that I didn't respond.
July 26th.
Could you hand that email if you'd print it off to the chair, please?
Yeah, we could actually put it up on the screen if you like. We have it loaded up.
Now, this is in response to their not their deficiency, but their timing. I know what the timeline of the project is, and I'm looking at it through the lens of the county. We took this permit in August of 2022, right? We sent a deficiency report out in December. The last correspondence was in March. For 5 months, there was no response to the county. That's the lens that I'm looking at. It was in their ball court more than it was in our ball court. And that to me is not pursued in good faith. And I'm looking at it through, I'm issuing 170 building permits a year. This never happens. We're expiring in process. Something's wrong on your end. You're not ready to submit for building permit application. Something's wrong here. And I looked at all that documentation. I reviewed it with Leslie for lot 3. I reviewed it with Larissa for lot 1. Listen, this never even made it to the building department, never even made it to my department for review.
Those of us who are in the architectural world or deal with the county, we get your side of it. What I would like to do is channel this toward us. We heard a lot and there's a lot of detail, but I think the members of the board can form whatever they think ought to be able to get moving in a thought process that takes us in a direction, because by the time we're done, it's like an up or down thing, right? And we've heard a lot, and we can I have, and I've assimilated a lot. And I would like the board to create their comments and questions directed toward how do we get to a decision or a consensus or wherever we're going to get without getting bogged down in details. Right. Right, does that sound right?
Yeah, that sounds great.
I do not see a date on this email. You're contending this is a March email. Am I missing the date?
No, it's a July 26th email. And if any, it's all about what was happening with lot 3 and why and how we needed to preserve the vested rights. And
how do we know when this was sent to Mr. Erickson?
The date is on the upper right-hand corner when it was sent. Says July 26th.
Okay. Okay, yeah, it was under a picture of myself, actually. All right, thank you.
And I would hope that this would address your concerns about any disrespect. None of our professional team ever exhibited any disrespect.
Yeah, the atmosphere.
They were bending over backwards to be cooperative.
Stuart, the atmosphere of this room is not about disrespect that I can perceive.
Okay.
I mean, after
I'm very
all,
defensive of the staff there that busts their hump. I may have misread it, but people that work for the city work very hard and I appreciate it. In my mind, I've formed an opinion. I'm happy to share it and have the rest of the board debate so we can try to get to a decision. Is that?
I would like to respond to what you're saying.
I just wanted to answer your question that I've worked a long time on this project since your first application, 2018?
Probably, yeah.
2018, I've never felt any disrespect from this team, ever.
I think what is frustration that happened
Yeah.
after it was deemed abandoned.
It's
Now,
always
there's
expression
never
of
disrespect.
Okay, because the building supervisor has a tough job and I respect that. My opinion here, that just so you know what I'm thinking at this moment is that it's perhaps been difficult and it's moved more slowly, but there is evidence of real work and good faith. And I would encourage the building supervisor to grant that and extend the period. But if he feels really that it's not something he wants to do, then at this moment, before I hear other comments, I would be likely to agree with the appeal and grant the extension.
Okay, well spoken. Thank you, Stuart. How about other members of the board? Commentary on what they would like to, how they would like to influence, or Tom, go ahead.
Well, my thought process is, well, what I've listened to is it's not so much finding fault with anybody. It's how the hell do we solve this thing? And we should be looking on a positive note and say, okay, if we do this, and we do that, are you happy? Are you happy? Can we solve it? I mean, can they do anything to get the permit, or are they?
Yes, we're willing to do whatever it takes.
Yeah.
We always have been. We want to see this project through.
Yeah, we just want to finish.
That's very clear from you guys.
Yeah.
Anybody else on the board? Thank you, Tom. And I think I have comments on that as well. Anybody else on the board, out there, please?
Yes, this is Bill Argyros. I have a few comments. First, Jeff and the staff, I don't know how you guys do it. An overwhelming amount of work. And a project like this with so many factors, I almost can't see how it could possibly get done in a 1-year time period, especially with some of the delays that you by necessity had to have. To me, the controlling issue in this case is very simple, and it comes from Pitkin County's own code, and it says it's 1 year unless it's pursued in good faith. And my comment is, I don't see, well, first of all, good faith also implies the evidence of bad faith. I don't see any evidence of bad faith on the part of the applicant. And it also implies abandonment in this case. And I don't see any evidence of abandonment either. I see two groups frustrated by the length of time it took to get this done. And I would ask that you work together to complete this project.
Very, very good. Anyone else?
I would echo that 100%. A tremendous amount of time, effort, and money has been spent on this by all the applicant and all the consultants. I think somehow we need to work together to get this agreed upon and pushed through. It seems like there's substantial evidence that a lot of work has been put into this up until that September 7th date.
So I would make. a motion.
I echo those comments as well.
So.
And I do think there is an opportunity. I deal with this a lot professionally, and it is very challenging to get everything done in the time frame. And I have deep respect also for what the county staff is up against. And I think, you know, always looking at things as lessons learned, maybe some different communication on both sides in terms of expressing, hey, this is what's happening on our end in terms of how we're advancing this ball. But then also looking at extending vested rights, which I know gets very sticky, but maybe that was a better approach with this, knowing the complexity of the lot 3 and what was required.
Yeah, I echo that. I don't think it's the county's obligation to babysit the timeline of every.
Correct.
It can't, absolutely can't. But I think maybe what they can do better going forward is make it clearly identifiable what date is that's critical path to this 12-month duration. And put the ball in the applicant's court and say, it's up to you guys. Make sure you don't exceed this. Go.
All right, great, thank you. Do we leave out any member of the board that hasn't spoken? Myself.
No, I am sorry. I need to go. Do we need to have a vote?
I will make a motion so you can vote if you like. May I make a motion, Chair?
Wait, I don't think we've.
Sarah, I haven't had a chance to speak yet.
Exactly. I'm sorry.
So, just one clarity, if Sarah were to leave, we still have a quorum.
Okay, we can still leave. We're all heading in the same direction here.
All right. Thank you all. Thank you. Bye.
Thank you.
Sorry, Chair.
The question I have for everybody, I mean, this is so elemental. If there had been a phone call in December that says, hey, we're still working on this thing, we wouldn't even be here today. You disagree, but what we're talking about here is this siloing that's bigger than us and the people in this room. We've got an applicant going on parallel tracks with complex approvals. And we have it channeled down to the building official that says, where are you guys? I got a building permit that expires and it's going to expire unless somebody tells me otherwise. And that's within his rights, almost his obligation. He's saying that's his obligation. And it is. And there's somehow in this complicated, I deal with the same thing, you know, upstairs, so everybody, it's daunting to approach the county with an application. I mean, just about any kind. This has been going on for half a decade. And it's clear, Mark, that you had no intention of abandoning. Does anybody believe that the applicant intended to abandon this project? I don't think so. I do. You do because, you know, you have that silo of an obligation for authority that this is really a land use issue. And you're the building official. And you don't know what's going on. And there's a lot of complexity going on here with land use issues that team has to confront and deal with it internally.
That should have been taken care of prior to applying for a building permit application. When they apply for a building permit application, it should be able to be reviewed and approved and issued. We issue on average 230 days, not 360 plus.
With all respect, we were fixing an approval that the county shouldn't have given.
In any event, we're on to board comment, so
Yeah, okay.
let's wrap that up.
Yeah. And amongst this, the fire department says, we need this. And it takes you, I mean, an applicant takes you way off. I've been there, done that. So there's a parallel thing going on here, but Jeff, you're seeing what you're the authority and I think you're out of the loop on some of this. Why we don't communicate more, I don't know. It's hard when you're a bad hand and you guys are kind of a wall. And it's not like pick up the phone and have a friendly conversation, like you're part of the team. So it's very easy for them to begin to work in isolation. And that this kind of silo thing that we're all in at much higher levels than this. And we take this as a metaphor for what's going on around us at the Supreme Court right now while we're talking. So those are my comments. Would anyone like to make a motion to resolve this?
I'm happy to make a motion unless someone else wants to do it.
Sorry, Stuart, I couldn't hear you.
I will make a motion unless someone else wants to do it. Okay,
Anybody?
I'd like to acknowledge it and thank the staff and recognize their frustration with this process. I make a motion that we grant the appeal and give an extension on these permits based on the evidence of good faith work on behalf of the applicant.
Okay, is there a second to that motion?
I'll second it.
Anybody, okay, on the board, anybody want to jump in and
Could I jump in and clarify that under the law, it's not actually an extension? Our building permits just get reinstated. Like the appeal gets granted and our permits get reinstated.
rise that right?
But may I jump in? If you look to Article 6 of our authority under appeal hearings, it talks about the burden of proof. It talks about the materials, the experts, the evidence. And then at the end, it says, number 7, quote, "The board may reverse, affirm, or modify the decision or order of the building official or continue the hearing for presentation of additional evidence." I don't see the need for additional evidence at this point. So I would modify the motion by just saying the board is choosing to rule that we reverse the decision of the order of the building official.
So modified, so I'll modify my motion to reverse the decision.
Okay, anybody else want to add to this motion or?
I'd like to ask a question.
Okay, oh, sure. We'll hear everybody.
Okay,
This
so
point.
it's not an extension, it's just reversing it and reinstating the permits, but does that mean that there's no time period? It's just however long it takes, 2 years, whatever.
10 years.
It's what the code says. As long as we're pursuing it in good faith, we're back to, we live within the language of the
This
code.
man wants to build a house.
Go up there, we have broken ground.
Well, it looks like
We're putting in our roads.
We have a motion on the table. There's no further discussion from staff or from the applicant right now. Unless it's solicited by the board. If I haven't heard any of that, there's a motion on the table. It's been potentially, it's been seconded and
we're not done this.
our board comment. So.
And Jenny, could you remove the exhibit on so we can see all the board members? Thank you so much.
Yes, so I make a motion to reverse.
Okay, point. Let's take a vote. All in favor of the motion, say aye.
Please call out, if you do not mind.
by person?
By person.
Okay, give
Yeah.
me their names, or you call them out now.
Okay, so Greg Wood,
Aye.
Stewart,
The motion is to grant.
The motion
William?
first, yes.
Aye.
Same thing.
sorry, Tom,
What's the motion read now again?
The motion is to reverse the determination of the chief building official that the application has not been pursued in good faith.
I don't know on that.
And Wayne?
I vote affirmative, yes.
So, motion would pass, 4-1.
And we're done. Very good. Thank you, everyone.
Take the motion to adjourn.
Yeah, motion to adjourn, and what, second, okay, motion to adjourn.
Second, thank you.
Yeah, all in favor? Sounds unanimous.
Thank you, everyone.
Thanks.
Yeah, thank you.
Thank you.
Okay, Jim. I